Go ahead.
All right, good morning, everyone. My name is Sterling Kiga, Chairperson of the Authority. I'd now like to call to order the May 27th, 2026 Kalaeloa Special Authority meeting of the Hawaii Community Development Authority. The time is now 9:01 a.m.
Thank you, Chair. In accordance with section 92-8.7 Hawaii revised statutes, the Hawaii Community Development Authority is holding today's Kalaeloa special board meeting virtually on Zoom. The Zoom link details were included on the meeting agenda. Therefore, members of the public are welcome to join us on Zoom and also at our physical meeting site at the American Brewery Building, 547 Queen Street, second floor boardroom, Honolulu, Hawaii, 96813. The HCDA communications staff is hosting this meeting. Once this meeting begins, everyone will be muted for clearer audio. Board members, if you have any comments or questions, please unmute yourselves to speak. It is important that all individuals clearly state their name, pseudonym, or other identifier name each time prior to speaking. If you wish to provide oral testimony and you are attending virtually, please indicate so by clicking the raise hand button found on your Zoom screen. If you are attending in person, you'll be called to the front of the room in the order that you signed up. Before you begin your testimony, we ask that you identify yourself, spell your name for the record. Your testimony must be related to an item on the agenda. All testimony will be limited to a maximum of 3 minutes. When time is elapsed, time will be called out, after which you will have 30 seconds to conclude your testimony, and then your audio will be turned off. If you're attending in person, the presiding officer will call the next testifier. Keep in mind, this is an opportunity to share your thoughts with us. If you ask questions during your testimony, neither the board nor the staff is required to provide an answer. If the authority's connection for the remote meeting is lost, the meeting will be recessed until the connection is restored. If the connection cannot be restored within 30 minutes, the meeting will be terminated. The authority will continue the meeting at another notice date. Thank you, Chair.
Thank you. HCDA board members, please remain visible and audible during the meeting. Also, please acknowledge that you are present by either saying here or present. Let the record reflect that the following members are present. Vice Chair Ishii is excused. Secretary Lidson.
Ayo.
You, Member Miranda Johnson.
Here.
Thank you. Member Anderson.
Here.
Thank you. Member Evans.
Here.
Thank you. Member Strikes. Here. Thank you. Member Duvashel.
Here.
Thank you. And Member Gordner.
Here.
Thank you very much.
Chair, you have quorum.
Thank you. For today's meeting, board members will have an opportunity to ask questions or provide comments after an agenda item has been presented. Individuals from the public who have requested to provide verbal public testimony on a specific agenda item are on standby and will be permitted to provide their testimony respectively. Agenda item number 2 is decision making. This is the question: shall the authority adopt hearing officer Rodney K.F. Ching's findings of fact, conclusions of law, and recommended order in the contested case dated April 22nd, 2026 in the matter of Tada Rojas versus Hawaii Community Development Authority, contested case hearing 2025-001. Mr. Craig Nakamoto, Executive Director, will now present the staff report.
Thank you, Chair. The staff report for action is in packet tab 1 of your packet with the following just change to the on the page 2, April 25th should be April 15th. So let me provide some context and background for this. We are here today because petitioner asked through her request for a contested case hearing to be here. HCDA was set to consider and adopt the adoption of the revised Kalaeloa plan and rules on November 5th, 2025. We received a request for a contested case hearing from Ms. Rojas, and this was received before the action was taken. The board, having received this request for a contested case hearing, decided at the November 5th board meeting to defer the action on the revised plan and rules. I'll kind of repeat that because that is a significant fact. The board deferred action on the revised plan and rules, so the board did not take any action. Upon that deferral, the board had 2 ways to handle the contested case. Either they could have, one, acted as the hearing officer, or delegate that to another party to act as a hearing officer. The board decided to adopt the latter, and they asked the executive director to retain a third-party hearings officer. So the HCDA retained the State Office of Administrative Hearing to conduct the contested case hearing. The Office of Administrative Hearing assigned the case to Rodney Ching. The party, and after that, Gentry and Hunt intervened in the matter. So a pre-hearing was scheduled by the hearings officer. Present at the pre-hearing was intervener, petitioner, and respondent, Hawaii Community Development Authority, represented by their deputy attorneys general, and I was present as well. So the hearings officer went over the process for the hearing, the procedural matters, and then issued a summary of the procedural matters and the dates and so forth, including the hearing dates. At the pre-hearing, the hearings officer asked me to kind of ask our cultural consultant, Kealapono, to consult with Ms. Rojas. This was something that was ancillary to the contested case hearing. It was something that the hearings officer just requested me to do it. I agreed to do it. Hearings officer also asked the petitioner whether or not the contested case hearing was still going to go on after that consultation. And I recall that the answer was affirmative, that the petitioner still wanted the contested case hearing to go on. So it did. Our cultural consultant, Kealapono, tried to reach petitioner by email. The email was the email that was provided to us, and we did not get a response until very much later. In the meantime, given that the contested case was going on, the Hawaii Community Development Authority made a decision to file a motion to dismiss the contested case hearing, which we had a right to do. Interveners joined in that motion. The hearings officer then conducted a hearing on the motion to allow both intervener, petitioner, and respondent to be heard by the hearings officer. So that was conducted. There was, I think, ample time for all parties to present their arguments. Questions were asked by the hearings officer of mostly a petitioner and respondent. So that was held. The recommended DNO was issued on April 22nd by the hearings officer. It was served on all three parties. And and that's what is the subject of this board action, is to adopt or not the hearings officer's recommended DNO. Let me go over next, Chair, the petitioner's exceptions. So these exceptions were filed, and these are exceptions that were duly filed by the petitioner of objecting or accepting to the recommended DNO. There are a total of 10 exceptions in the DNOs, in her exceptions. So let me kind of address some of the pertinent ones. You'll have, so.
You'll have time to present after the executive director has finished his report.
My exceptions.
You will have time to present after the director has concluded his report. Thank you.
So exception one is titled erroneous finding adopting incomplete timeline, failure to recognize ongoing consultation and agency cost interruption. So let me address that, Chair. There was opportunity to consult with our cultural consultant. Emails were sent out to the correct email. There just was no response. At some point, after not having received a response and our motion to dismiss having been filed, a decision was made by me to suspend that consultation for now, for the matter, pending the outcome of the motion to dismiss, which was being considered at that time by the administrative law judge. As far as the timeline for all of that was something that was set out by the hearings officer at the pre-hearing statement. Exception number 2 is titled erroneous conclusion that the matter is premature. I'd like to direct the board for a moment to the staff report, and particularly the attachment to the staff report, page 6. So the response, or the page 6, what it says is, at the last sentence, the HCDA has not taken action or made a decision that affected anyone's constitutional rights. Period. The petition is premature. So I'm going to repeat that. The HCDA has not taken any action or made a decision that has affected anyone's constitutional rights. The petition is premature. Accordingly, the hearings officer recommends that the respondent's motion to dismiss be granted. Exception 3 is titled failure to apply public trust doctrine. On page 6 of the recommended DNO and the recommended order, the hearings officer states, on its face, the Kalaeloa recommendations appear to be designed to protect Native Hawaiian rights and public trust resources. Exception 4, failure to apply the Kapaa requirements. The conclusion of that is the last sentence. It says, because these steps have not been completed, the record is legally insufficient. Dismissal at this stage allows the agency to bypass mandatory requirements. That is in the exceptions. So at the November 5th meeting, if the board members will recall, we were poised at that point to recommend to the board certain recommendations to address the Kapaa analysis. For example, in attachment 2 to the November 5th staff report, there was a table, and you don't have it in front of you, but it's called Summary of Disposition Implementation of the Recommendations and Mitigating Measures Contained in the Kapaa Analysis for the Kalaeloa Master Plan and Rules by Kalaeloa Archaeological Consulting, LLC, October 20, 2025. In that table, it lists 10 mitigation recommendations that HCDA was going to implement. This is, through the master plan and rules. The first one, and bear with me, Chair, as I go through this, they're important. Number 1 was conducting thorough surveys to determine the current population of Puea in the forest, of Opailua in the subterranean waters, and Limo along the coastline. Second was cleaning of Orty Pond and turning it over to the community for access and educational purposes. 3, conducting archaeological surveys of the KCDD lands and development and implementation of a plan to protect the remaining cultural sites. 4, completing a botanical survey of the native plants dispersed throughout the KCDD land and a commitment to protect and preserve endangered population. Conducting a hydrological study of the subterranean water, how it is currently flowing, the amount of contamination, if any, and its impact on marine resources. 6, completing a study on the current marine conditions of the KCDD coast, including spawning of the mullet, to better understand how marine life will be impacted for future development. 7, conduct a study on establishing a traditional cultural landscape. 8, establishing an advisory council to provide non-binding advice to HCDA on cultural issues. This is the AHA Council. And looking into the possibility of a reciprocity, meaning HCDA will look into the possibility of imposing a fee on each development project applicant that will be used toward the maintenance, establishment, or expansion of the traditional cultural landscape. And number 10, promoting access for cultural practitioners. Through the development process, we envision that the advisory council will identify necessary access for cultural practitioners. So that was contained in the November 5th for action staff report that would have been adopted had action been taken. Those were the then mitigating recommended measures suggested by Kialapono. And those are suggestions from Kialapono that the staff, HCDA, was willing to accept and we're gonna poised to present to the board. As to the state of the Kapakae analysis, I don't think we're done yet. Although I mentioned that I had suspended the consultation pending the outcome of the motion to dismiss, and because we could not get a response timely from the respondent, I said it was suspended at this time. We fully expect to re-engage our archaeological cultural consultant, Kialapono, and to conduct more interviews of lineal descendants and others to complete the Kapakae analysis prior to any adoption of the revised plan and rules, as we are required to do. Exception 5, failing to recognize the legal significance of lineal descendant participation. So that is not correct. We recognize the participation of lineal descendants. We were poised to create that council to give them a greater voice, to give them more voice. I think the phrase that was used was 3 minutes at a board meeting is not enough. So we were poised to give them a greater say for each development. And that AHA council would be AHA council that consisted of cultural lineal descendants and also developers, landowners as well. And then, as I mentioned for the previous exception, we're going to continue to work on the Kapakae analysis, continue the interviews, re-engage with our consultant to do more interviews prior to bringing the Kalaeloa plan and rules back for consideration of adoption. Section 6, failing to address cultural and burial protections. So that's not true as well. One of the recommendations of Kialapono was to consult with SHPE and I think to consult with OIBC. So we recently consulted with SHPE, and I think we were going to also consult with OIBC. Exception 7 talks about failure to consider evidence of existing harm. Whatever the hearings officer considered is what the hearings officer considered. Exception 8, failure to consider title and property interest. What the hearings officer took all of the evidence into account when the motion to dismiss and made his ruling on it. So whatever he did or didn't consider, that's the hearings officer. Violation of due process under HRS section 91-9. Related to the contested case, as I mentioned, there was ample opportunity for the petitioner, the respondent, and the intervener to state their case, and they did. Exception 10, improper termination without hearing on the merits. The gist of this is petitioner accepts to the recommended order because it terminates the contested case without allowing a full hearing on the disputed issues of fact thereof. And that's not correct. As I mentioned, when we submitted our motion to dismiss, which the intervener supported or joined in, we had a right to submit that motion to dismiss. It was based on the law. At the hearing on April 15th, the administrative hearings officer considered the arguments of all parties. So those are the 10 exceptions that I wanted to go over. We are prepared, as I mentioned, I want to emphasize this, we are prepared to re-engage with the archaeological consultant, Kialapono, to re-engage with the interviews. Because the motion to dismiss was granted, now I think we're ready to proceed prior to adoption of or consideration of the plan and rules. Chair, I know I've taken a long time, board members, I know I've taken a long time, but I wanted to go over those points, our position in this and our recommendation, and also what we plan to do in the future if the board adopts the hearing officer's recommended order. And most importantly, how we intend to continue with the Kai analysis and conduct interviews. We have California ready to start those interviews. So Chair, that concludes my staff report and I'm open to questions from the board members.
Thank you, Director. So members will now have time for board member questions or comments. And then just so people know what's coming next, we'll have time for the petitioner to make a presentation, for any interveners to make a presentation, then for public testimony, and then we'll move toward looking for a motion. So members, any questions or comments for the director? Member Strikes.
Okay. Thanks, Craig. I just wanted to clarify, because in the findings of fact, you were pretty clear that the conclusion was that the action or petition was premature. If the board were to adopt the findings of fact, would that prevent the petitioner from putting in another request after the board takes action on the Kalaeloa plan, if they do?
Thank you, Member Straits, for the question. So the short answer is no. The short answer is no.
Okay, thanks.
Members, any other comments or questions for Director Nakamoto before we allow the petitioner to make a presentation? And just for members in the room, there will be time for public testimony right after the petitioner's presentation and the intervener's presentation. Board members, any other comments or questions? Okay, seeing none, we'll now allow the petitioner, Tara Rojas, to make a presentation. Ms. Rojas, if you'd like to come up.
Ms. Ross, you may come to the front of the room.
Okay. Is there no microphone needed?
No, the microphone here will pick up your voice just fine.
Okay, so. Well, before the board proceeds further, petitioner respectfully renews the request for continuance that I provided on Tuesday, yesterday, May 26th, as well as submitted written comment as well. And I'd like to state for the record that in the agenda item to submit written testimony, even that email is incorrect. So just, I sent it to the correct email, which was under oral testimony. So again, before the board proceeds further, petitioner respectfully requests renews the request for continuance, procedural objection, correction of record, and amendment of agenda item 2.1. Petitioner timely filed exceptions. The board notice did not clearly state those exceptions will be formally heard today before final action. Affected witnesses. Okay, so I would like to also ask if you have my exceptions with you right now, the May 3rd and 4th.
The exceptions, along with all the other matters, are concluded in or are included in the record of the contested case hearing, which all the board members have been provided with.
They were all provided.
Okay, and do you also have the request for continuance as well? Because that was not mentioned in the memorandum and nor on the agenda.
Well, we have several copies of that, and that was also provided, Mr. Ross, to the board members as late as this morning.
Because I received this notification on May 21st, so I just, which usually a time stamp copy is usually provided and emailed back. And that May 3rd, May 4th exception was not,
Of the.
I mean, it was timestamped, but it was not included on this memorandum.
This memorandum was drafted ahead of time, but all of your exception, your several emails, latest one being this morning, were all sent to the board members as late as this morning.
Okay,
Okay,
but just for the record, if it was set ahead of time, and knowing that I filed within the deadline by the May 4th, so it should be included or updated, the memorandum, to reflect all items submitted, okay? Okay. So are we allowed to go over my request for continuance since it was not part of this agenda?
The agendized item is decision-making on whether or not to accept Rodney Ching's findings of fact, conclusions of law, and recommended order in the contested case. And that is the only action on this matter that the board is considering today, Ms. Rojas.
Here's the thing, because I received an email from Craig that I was able to file exceptions.
Your exceptions have been filed, received, and are included in the contested case hearing record that has been considered by all of the board members who will testify that they've considered it before they take any action on this agenda items.
But it's not on this agenda.
The contested case
The
record,
exceptions is not listed in the memorandum, so I have this right here in front of me. And let's go over this because while you stated the background history, but I have corrections to the history as well. And so on the agenda item for today is the finding of facts, which is item 2.1. And in there, it is in the timeline, the background history. This did not reflect the May 3rd and 4th exceptions. Yeah, and so. Yeah, so again, before the board proceeds further, petitioner respectfully requests the request for renewance, procedural clarification, correction of record, and amendment of agenda item 2.1. Petitioner timely filed exceptions to hearing officer's recommended order, request for opportunity to be heard prior to final decision, and in the alternative, motion for reconsideration on May 3rd, 2026. Via email and May 4th, 2026 by hand delivery to the authorities of office pursuant to HER 15-215-53 and HRS Chapter 91, including HRS 91-9, 91-10, and 91-11. Under HAR 15-219-53 and HRS 91-11, adversely affected parties are entitled to file exceptions and present arguments before final agency action. However, agenda item 2.1 and the accompanying 4-action memorandum do not identify, reference, or place petitioner's exceptions on today's agenda, nor do they state that petitioner's exceptions would formally be heard prior to final board action. Instead, the notice states only that the board would consider adoption of the hearing officer's finding of facts, conclusions of law, and recommended order. As a result, the notice failed to clearly inform petitioner, supporting participants, lineal descendants, cultural practitioners, and the public, whether the exceptions were formally before the board today, whether oral argument would be permitted, whether witnesses, testimony, exhibits, declarations, or rebuttal evidence will be allowed, and whether the board intended to deliberate and vote on final agency action immediately thereafter. HRS 91-9 and HER 15-219-50 provides for reasonable notice regarding the nature of the hearing and the issues involved in contested case proceedings. Petitioner respectfully requests or submits that the notice provided here was insufficient because it did not clearly notify the parties or the public that the petitioner's exceptions would formally be heard before final board action today. Additionally, HRS 91-10 contemplates meaningful opportunity to present evidence, exhibits, rebuttal evidence, and witness testimony necessary for full disclosure of the facts. Petitioner and supporting participants already submitted exhibits and materials into the record and were prepared to proceed. If proper notice and procedural clarification had been provided regarding a hearing on the exceptions. However, because no clear notice or clarification was provided, affected participants could not reasonably determine whether they needed to rearrange work obligations, court appearances, travel, family obligations, childcare, or other prior commitments in order to appear prepared for testimony and participation in a contested case hearing on the exceptions, which includes today. Multiple lineal descendants and supporting participants had prior court proceedings and other pre-existing obligations scheduled during the same time as today's proceeding and could not reasonably anticipate that petitioner's exceptions would formally be heard due to the lack of proper notice and procedural clarification. I've already stated the HER and the HRSs. Petitioner further respectfully submits that Executive Director Craig Nakamoto's response merely advised, again, Executive Director Craig Nakamoto's response by email merely advised petitioner that the May 27, 2026 special Kalaeloa board meeting would proceed as noticed and that the board would receive petitioner's email, but did not clarify the procedural issues raised regarding notice, hearing procedures, oral argument, witnesses, exhibits, or whether the exceptions will formally be heard before a final agency action. Due to the continuing ambiguity created by the agenda and the lack of inclusion of my May 3rd and 4th delivered exceptions, and the response received from the Executive Director Nakamoto, petitioner thereafter filed a supplemental notice of procedural objection and preservation of rights, formally objecting to proceeding under unresolved procedural ambiguity and preserving petitioner's administrative and due process rights. Despite those filings and objections, no further clarification or amended notice was provided to petitioner or the public prior to today's proceeding. Accordingly, petitioner and supporting participants arrived today without clear understanding of what procedures would govern or what was expected to occur. All of that was included in what we filed timely to you all before today's meeting. Petitioner further respectfully notes that HER 15-219-54 contemplates completion of the exception and argument process before final decision by the authority. Again, petitioner further respectfully notes that HER 15-219-54 contemplates completion of the exceptions filed on May 3rd and 4th and argument process before final decisions by the authority. Petitioner also respectfully notes that the 4 action memorandum, so if you have it in front of you right now, contains a material clerical error regarding the hearing chronology, incorrectly stating that the hearing occurred on April 25th rather than April 15th. Again, that was not mentioned at the start of this meeting. Again, that error combined with the absence of any express reference to petitioner's timely filed exceptions within the agenda and public notice further supports petitioner's request that the agenda notice be amended to provide accurate and proper notice before any final board action. Accordingly, petitioner respectfully requests continuance of this matter, clarification of procedures, amendment of the agenda, and public notice to expressly identify petitioner's pending exceptions, correction of the record, and opportunity for meaningful participation before any final board action. That is significant. this is gonna be in the public record. There's clerical errors, there's procedural ambiguity, and there is prejudice against the process, and there are HAR and HRSs stated to allow. Thus, we petitioner and parties affected respectfully request continuance of this matter before final agency action. That's what we asked for clarification, how this was going to be, because in the previous email, it was stated that I was gonna be treated like regular ordinary public testimony and only given 3 minutes. And the reason I'm gonna add in that I'm coming here before you today, as for the past 2.5 going to, this is our 3rd year for every board meeting, is because of the process that did not allow for to provide evidentiary facts and findings. Thus, the call for contested case. And mind you, may I add that we also came before you, myself, cultural practitioners, lineal descendants and heirs, as well for previous items. For example, the way quote in which there were items that were being accepted and modified and amended. And that was clarified with the approval of the decision to not allow the wave pool. So going against own rules and recommendations. So I've been in this with the amendments, and you're saying that it's premature. 3 years is not premature. 3-minute public testimony does not allow what needs to be presented. AHA Council, some I noted here. AHA Council, culturally insensitive. Okay. So before continuing, will petitioner's request be granted for continuance?
Could you just please finish your presentation?
Because if this is being considered as an argument and as a presentation, and for all the reasons just stated, that we were procedural ambiguity, that I want to make sure before I continue.
Can I ask a question for clarity? Is her presentation being considered as a response to the exceptions? Is she being heard first? Because she did send an email requesting for clarification on what was going to be heard today. Even when I read it, it didn't say exceptions. So I had to change my schedule around to try and be here because it was unclear, so I could support her. And it doesn't say that. And so before you move on, you give her like saying, continue your presentation, I need to be clear that she's talking about that first subject. And then, well, if she needs to, right, because you guys are forcing her to do so, we can address the exception part. But before that, can we please stay on point of the continuation or requesting?
If you'll allow me to repeat myself, the only item that the authority is considering right now is the agendized item. If the authority will adopt hearing officer Rodney K.F. Ching's findings of fact, conclusions of law, and recommended order in the contested case dated April 22nd, 2026 in the matter of Tara Rojas versus Hawaii Community Development Authority, contested case hearing 2025-001.
Okay.
That is the only item that the authority is contemplating at this time.
But if the authority is contemplating that item under your own HARs and HRSs, before you can contemplate any voting on a final decision of a dismissal or anything, right? We need to have a proper hearing, and she has to have that proper opportunity to present her argument. Now, how can she present all her exhibits, present her argument, bring forth lineal descendants if proper notice was not provided to us?
Chair, can the speaker identify?
Yeah, could you please identify yourself for the record?
Oh, my name is Hiva Kaheahu Rodenhurst, and I am a lineal descendant that was a part of,
Are you of counsel for the petitioner?
no, I'm a lineal descendant.
Okay, so could we please allow the petitioner to conclude their presentation?
I mean, before you continue presentation, nobody answered anything for us.
Yes.
We need clarity.
Okay. This time is set aside for the petitioner, Tara Rojas, to make her presentation. The board members are not required to answer any questions. This is not a question and answer setting. It's an opportunity for the petitioner to make their presentation.
And
Are you able to allow a special appearance because we don't have an attorney? You folks do have the privilege of having the deputy attorney general. And I do know that in civil court procedures, you are allowed to do a special appearance. So are they allowed to do a special appearance?
So-
I mean, are we gonna follow civil procedure?
So ma'am, after Ms. Ross makes a presentation,
Mhm.
interveners will make a presentation, and then the public, including you, and you will be able to testify and present.
No, I just was asking a
Yeah, yeah.
question if she can make a special appearance because you're stating here that she's not allowed to be here because you want the petitioner.
I'm saying that
And we don't have a
she
counsel.
can testify, yeah. She can
Well, she's not asking, I'm not asking if you can testify, I'm asking if she can make a special appearance, which is part of civil procedure. It should be allowed because had we had enough money to have an attorney, the folks are represented by the deputy attorney general. I think it's just fair that we're just presenting something and that she needs some assistance. I don't think it's right to
Although-
just cut her off
although-
from that opportunity.
Although Ms. Ross did state in the petition all throughout that she's proceeding, just.
Yes.
Yeah.
Oh,
Correct.
oh,
And
but-
we are allowed a special appearance. Is the deputy here? Is the deputy attorney general here? Cause I know all 300 pages of,
Yes,
Civil
I'm
proce-
here.
can we have them queue in here? That we're allowed to have somebody appear with special appearance on behalf of Tara to assist?
And I would like to request that because the fact that you're saying that, yes, after I finish, you can testify, we know how it's gonna be. 3 minutes, 3 minutes, 3 minutes, board, any objections? Yes, 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 pass. If this is not, I'm not allowed to fully present and I had not been responded to on clarification on this meeting, then this is not what, this needs to be heard. I need proper hearing according to your own HR, HRS, before you adopt decision
Miss,
or recommendation of the motion to dismiss. And I would like to,
One more thing that we want to clarify is that you said that you guys are gonna vote on the decision. And like we're saying is that on the agenda, when you list what's going to be discussed, it doesn't say her exceptions. But here he is reading the exceptions to us, forcing us into a hearing and argument
Mhm.
without proper notice so that we can bring everybody that we need to that is affected by this contested case.
yeah, let's hear from the.
and then finally,
Hold on a
additionally,
second.
there's a clarification.
Sorry, you've raised some procedural
Yeah.
concerns, so if you would allow our counsel to answer them.
Yes, this is the time to present your arguments on the exceptions. So when this item was put on the agenda, your opportunity to present exceptions is part of this agenda item.
It's not listed on the agenda though.
It's not listed on the agenda.
Attorney General,
Deputy.
Deputy Attorney General, it's not listed on the agenda, and that's why we asked for clarity before coming here, and we weren't given that clarity. Therefore, we filed for a request for continuance.
And also the request for continuance is because we have a civil case currently that we're all supposed to be in attendance in for our farm in Waihole in Kaneohe District Court, which was notified to the board. And so we have our family split into 2 different places. So that's also the reason why we requested a continuance. And I just had court on Monday. I'm very well versed in it. And my attorney was able to request a continuance because my presence wasn't available. And so that's what we're trying to ask your recommendation, Deputy. If that would have been something that would have been looked over, that would have been a possibility for us to have this special meeting continued.
And
Because we do have a court case today in district court and we can present the evidence if you duly wanted to see it, we have it.
And additionally, I would like to add that this was on the May meeting, and it was sent to us that it would be postponed, deferred until the June meeting, the June 3rd meeting. And that I would have 3 minutes to testify
Unless we filed exception.
unless we filed exceptions,
That's
and
okay.
thus that's what we're planning on June 3rd. However, on May 21st, just on Thursday, I received notice from Craig, the director, executive director, that we were having this special meeting, not the June 3rd, that this May 27th meeting was being called, and that this meeting was being called.
Yep.
And so I filed timely my exceptions, noted that the exceptions were left off of this memorandum agenda, in addition to the clerical item of the April 25th, supposed to be April 15th, that the hearing was heard. And here we are now, and I asked for clarification, procedural clarification of what this meeting is
Prior to being here.
prior to being here. And I did not receive any response. I sent it through, yeah. Okay.
Yes, understood. So the agenda item includes your opportunity to present exceptions. It does not need to be separately agendized.
Where is it? Where does it say that on the agenda item?
It's not in the memorandum.
The exceptions do not need to be separately agendized, so the hearing.
No, it's not in the memorandum of background information.
Is the only item that needs to be on the agenda, and your opportunity to present exceptions is part of that.
It doesn't say that though, and we are afforded, we're public, we're pro se, we should have proper notice. You could literally say, put that part inside where it's saying, oh, we will hear exceptions today. And it doesn't say that, so we're being prejudiced because we are not receiving proper notice.
Chair, on the point about procedural clarity, I'm very unclear at this point if the other people who are speaking on this item are in fact involved in the matter of Tara Rojas, or if they are in fact representatives of Hui Kuleana o ko Hawaii Pa'aina ma Kalaeloa.
I'm a part of both.
Member Gordner, if you, I'll respond to Member Gordner, thank you.
Oh, yeah.
Member Gordner, this agenda item in front of us is in the matter of Tara Rojas, who, to our knowledge, based on the contested case hearing record, is the only petitioner on this matter. And so,
that being the case, in terms of procedural clarity, it should only be the petitioner pro se speaking on this item and
correct.
At the table. Is that correct?
That is the concern
because on all of our legal filings, it is only Tara Rojas who is making these claims and exemptions.
I would like to object to that because if you look into the filings, my name is in there, written multiple times throughout this whole filings, the exceptions, everything, that I was a part as a lineal descendant that she brought forward.
I'm gonna request, Ms. Rojas, that if there, is there anything that has not been included in all of your correspondence, which the board has reviewed as part of this contested case hearing record, that you have not presented today? Any procedural concerns you have, I'm sure you will have abundant opportunity to file any number of legal appeals after this. And so is there anything that you haven't already presented that you need to present before you conclude your presentation?
And Ms. Rojas, this is Deputy Attorney General speaking again. Just to note, this is your opportunity to present argument on your exceptions to the board prior to decision making. So this is your opportunity to say anything you want on the exceptions.
Okay. Here.
And Ms. Rojas, if I can provide advice, your exceptions and your correspondence has all been included in this record, and the board members in a few minutes will testify whether or not they've reviewed the entire record, which now runs to many, many pages. Speaking as a board member who has reviewed the record, I just want to let you know that I take seriously what's in the record. I've reviewed every page of it, taking substantial time. And so if there are additional things that are not included in the record, I invite you to state them here. But if you want to use this time to just repeat what's in the written record, you're welcome to do that as well.
Right.
So I'd like to testify.
This is just to,
Yeah.
you're gonna have to put
Okay.
right here.
And the underlying, like, before I continue with what I realize now is gonna need to be my argument, which I was asking for a simple consideration to let me know. I sent it over the weekend, I sent it, or actually yesterday, sent it this morning. Can you let me know what today is? So at the underlying of this all is, there's also a title dispute. I'd like to correct for the record about the continuous repetition of the fact there was ample opportunity to respond and that there was no participation by myself petitioner with the culture consultant. I'm gonna do that first, correcting. Okay. So the incompleteness of consultation was not caused by inaction by descendants or petitioner, but by delayed communication, multiple Kona law disruptions, and interruption of consultation before completion. At the outset, petitioner respectfully states for the record that petitioner proceeds today under continuing objection and preservation of rights due to insufficient notice, unresolved procedural ambiguity, and denial of petitioner's request for continuance and procedural clarification. Again, petitioner respectfully preserves objection under HAR 15-219-53 and HRS 91-9, 91-10, and 91-11, including objection to proceeding toward final agency action, despite the agenda and public notice failing to clearly identify that petitioner's timely filed exceptions would formally be heard prior to final board action. Nowhere in there does it state that didn't need to be filed separately. I did file it. It's not on the agenda. It's not in the memorandum in the background. I emailed, could you clarify if this is what's being heard? Am I required to present or presentation and argument? And I received no response prior to coming to today. Yeah, and according to your HAR and HRSs, it states that the rules need to be clear and relayed to the adversely affected parties. Petitioner further preserves objection that affected participants, lineal descendants, cultural practitioners, and supporting witnesses were prejudiced in their ability to prepare and participate due to the insufficient notice and lack of procedural clarification provided by the authority. I would like to clarify for the record again that petitioner did not timely respond or did not reach out to the cultural consultant. It was through HCDA's incorrect contact information, both email and phone number, that the cultural consultant could not contact me. It wasn't until he wrote the February 9, 29 letter that I received in March that he was reaching out again. I did not participate due to, or petitioner did not participate, the lack of participation due to he was not able to contact me. I did not receive the communication until by certified mail in March. And then as we expressly stated in the exceptions, MF filings, and throughout this contested case hearing, that the 3 Kona lows also affected the continued participating. We were still actively involved in consultation. Proceeding under continued objection, petitioner respectfully opposes adoption of the hearing officer's finding of fact, conclusions of law, and recommended order. First, the recommended order improperly concludes that petitioner's claims are premature because the proposed amendments to the Kalaeloa Master Plan were not yet fully approved. However, petitioner respectfully submits that the challenged conduct is not limited solely to final approval of the master plan amendments themselves. The record demonstrates that a contested case was granted hearing officer assigned, and consultation was active, ongoing, and producing evidence before HCDA halted the process. Before I continue on this, I want to add in that this contested case hearing, original date, was before the legislative session or right at the start. And it was due to HCDA's request to postpone to defer, move back the dates of the contested case hearing. Petitioner accommodated the request to postpone so that HCDA could follow their bills, your bills, in the legislative session. Had I not accommodated the contested case deferral moving back, you would not have then decided a week before that new date was to be heard, in which we were able to present all the exhibits, bring all of the cultural descendants, the lineal heirs, the specialists, the public, because that's when the motion to dismiss was filed. Right before the deadline of exhibits to be submitted, which is 1 week before the contested case hearing. It was done on a Thursday or Friday, the motion to dismiss. When petitioner was already preparing to submit exhibits, evidence, and all of my arguments. So petitioner had to deal with preparing for the status hearing of the motion to dismiss, at the same time, pro se, realizing that the April 1st deadline, because of the postponement requested by HCDA so you could follow your bills. And so thus I submitted my supplemental petition just in case, as a pro se petitioner, to meet the April 1st original deadline. So again, I accommodated this pushback so you could attend so HCDA could attend the legislative session to follow your bills. Which, by the way, also tried to exclude lineal descendants as part of HCDA. And then we had the status hearing, and then motion to dismiss hearing was scheduled. That is not on the record. I'm going to put it on the record. The hearing officer asked what date. I stated a date. And to accommodate the HCDA and interveners scheduling, I accepted to move it back. And thus here we are now, sitting before you. I'm asking you, can you at least can you provide petitioner with procedural clarity and not prejudice? And prejudice is what petitioner has been experiencing from November until now, from September, November until now. Okay, I would like to put on the record that I've been coming for 2.5 years, and this is what I stated in the hearing, and then the pre-status hearing, and then the motion to dismiss hearing. Several times I had to repeat myself regarding the fact that I've come to these board meetings for 2.5 years, letting you know about the water issues, letting you know about lineal cultural descendant issues, letting you know about the land issues, letting you know about the sewer issues, letting you know about the traffic issues, letting you know about the effects to the limu that development has by breaking the spring. Thus, the Eva Beach limu management area is no longer full with limu because of these developments. So for 2.5 years, I've been saying, and all I've got was 3 minutes, no back and forth discussion. Thus, I called for a contested case so I could have the opportunity, so petitioner could have the opportunity to be heard and present all these exhibits and the facts and bring the necessary people to the discussion. And I have been in good faith following and meeting all of the deadlines just to be heard. Petitioner's life has been put on hold pro se, to stand for the protection of Honolulu, in which the Kalaeloa Master Plan is part of. Thus, I am saying right now, for this record, due to my accommodations as a person of this place and the Aina with a good heart and good faith, not realizing that this agency, HCDA, would throw all these obstacles for me to even be heard. Up until the May meeting, in which a few days before I was sent an email that we're gonna postpone. So we were gonna postpone the May meeting to June board meeting, Kalaeloa board meeting, and that I would be given 3 minutes to testify. Back to a public participant testimony, not as an active petitioner in a contested case hearing. And at every obstacle, just to be heard, deferral, motion to dismiss, now no procedural clarity. Now I'm saying you're allowed to present all your arguments now before we decide to adopt the motion to dismiss. Can you understand that if this is what you do to one member of the public who appears for 2.5 years, it's been me and developers attending. So when the public reads the documentation about these meetings, that there was a public hearing, 2024, it was me and the developers. So that when the public hearing comes around again regarding the approval of these Kalaeloa Master Plan amendments, it's me and the developers who then joined as interveners to my contested case. So what's on paper does not reflect the reality. And in addition to today's agenda item, which does not even reflect, not that it doesn't have to be separate, but at least state in the memorandum of background history, the truth that I submitted May 3rd and 4th, my exceptions, that should be there. The correction should be of the hearing date should be included as well. And not reiterating that the petitioner did not participate, did not petition. We explain why, but you don't bring it out so that the public and transparency, though it can be on the record. We stated the Kona lows. We stated the incorrect contact information. So thus, that's all I need. I need to add all of this in because this is 3 years worth of coming to you guys and just the opportunity to be heard and not just to be ignored during your board discussion and the whole board just votes everything through. That's why I called for this contested case, because I brought all this information. I've asked for permission from the library to bring all the EISs, like 12 of them, which are not supposed to take out. They gave me permission to bring them. And all I got was 3 minutes. That was it. And it kept moving forward. So I'm going to continue here. Proceeding under continuing objection, petitioner respectfully opposes adoption of the hearings officer's finding of fact, conclusion of law, recommended order. First, the recommended order again improperly concludes that petitioner's claims are premature because the proposed amendments to Kalaeloa Master Plan were not finally approved. But I just share with you all that I see how the process continues to move forward. Whether I speak at 3 minutes as a public testifier or as petitioner contested case hearing, in which I have continuous until today been blocked from presenting and being able to speak and bringing the people who need to speak. However, petitioner respectfully submits that the challenge conduct is not limited solely to final approval of the master plan amendments themselves. The record demonstrates that a contested case was granted, hearing officer assigned, and consultation was active, ongoing, and producing evidence before HCD halted the process several times. Petitioner first raised concerns and requested consultation with lineal descendants during the September 3rd, 2025 public hearing. And I would like to state for the record, thereafter, HCDA initiated a kapa'akai process and retained Ulukoa in approximately October of 2025. I would like to put on this record, since this is my opportunity to do so, but I'm still requesting for a continuance. But I'm gonna put this on for the record. That this public hearing was halted because I came up as well during them and it was deferred, the approval. For the 2 years, there had not been a kapa'akai analysis. It was only after I called for contested case September 3rd, 2025 public hearing, just me, in which HCDA now initiated a kapa'akai in October, which is again incomplete. Ulukoa initiated consultation efforts in January 2026. However, HCDA had provided Ulukoa with incorrect contact information for petitioner, including incorrect email and phone information, which materially delayed successful communication and coordination. In an effort to resolve the communication issue and continue participation in consultation, a certified letter was sent on February 26, 2026, which was received on March 2nd, 2026, establishing the first successful direct communication between petitioner and Ulukoa regarding consultation. Following that contact, petitioner immediately began coordinating with lineal descendants, cultural practitioners, and supporting participants regarding Kalaeloa and Honouliuli consultation efforts. Additionally, lineal descendants came forward, testimony was being collected, interviews were actively being scheduled, and supporting cultural information was being provided to Ulukoa. The record further reflects that during March and April 2026, multiple Kona low storm systems substantially disrupted communications, utilities, travel, scheduling, and participation throughout Oahu. Your board meetings may continue on, but people's lives and ability to continue this participation are and have been affected. Okay, so including the March 10th through March 14th Kona Low event and the April 8th through April 12th Kona Low event, there actually were 3 Kona Low events. Despite these circumstances, consultation continued in good faith. Lineal descendants and supporting participants are prepared to testify that they remained in active communication with Ulukoa and will continue to coordinate consultation, participation, and scheduling. However, before consultation could be completed, so even before this meeting, HCDA directed Ulukoa to cease interviews and halt the consultation process on or about April 8th. I'm gonna have a pause there. Because the original date of the accommodated scheduling to push back this contested case, which should have been in February, it was supposed to be April 8th, 9th, and 10th, if I believe, or let me look in my calendar. But that was about the time we were supposed to have our contested case hearing. Had HCDA not requested, then we would stop this consultation and requested the motion to dismiss. So accordingly, petitioner respectfully submits that the record does not support the conclusion that consultation was incomplete. What you mentioned at the start of this meeting, consultation was incomplete due to inaction by affected descendants or participants or petitioner. Rather, the record demonstrates that consultation was actively underway, materially affected by communication issues, severe Kona Loa disruptions, and then interrupted by agency action before completion. Second, under Article 12, Protections and Kapa'akai, agencies are required to reasonably identify cultural resources, assess impacts to traditional and customary practices, and develop feasible protections before final approval and implementation of agency action. The planning and pre-approval stages are precisely when consultation, factual development, and participation by affected descendants and cultural practitioners are required. I heard what you said earlier. I know testifiers can address them themselves, but I would like to say that also for the record, cultural lineal descendants and affected Honouliuli, Kalaeloa beach area residents have come forward in the 2.5 years, which with a public testimony 3 minutes, and they were not included in that October kapa'akai analysis. Petitioner respectfully submits that dismissing the contested case before consultation and factual development are completed undermines these protections and prevents meaningful participation by affected persons. Third, the record now contains unresolved issues involving culture and bureau protections, lineal descendant participation, traditional customary native foreign practices, environmental and shoreline concerns, title and historical land issues associated with Honolulu and Kalaeloa, and incomplete consultation and evidentiary development. And I want to add. Yeah, and all of the concerns that I have brought forward regarding traffic and again, environmental and shoreline concerns. If you're saying that this is premature without even allowing me and linear cultural descendants and public to even have a contested case hearing, you can see, and you know, because I've been to your Kalaeloa board meetings, your Kaka'ako board meeting, the general board meetings, and I've heard you discuss the impacts, environmental impacts and shoreline impacts. The development and the stopping of the fresh water to the salt water to form the brackish water for the limu growth. There is no limu in the limu management area. So we know how the decisions made here affect the land, the environment, the water, the ocean, and the people. And I was going to bring as well earlier regarding just the overdevelopment, the traffic, the one-way in, one-way out, because I also attend neighborhood board meetings, and we also lived the tsunami warning as well. And these issues that I'm bringing forth as well here, and that we're prepared to bring in the contested case hearing. These issues are being discussed here. They've been discussed in neighborhood board meetings. They've been discussed in neighborhood town halls. They are being discussed in county council meetings, planning commission meetings here on Oahu and other islands. So everything that I'm bringing forth needs and deserves, without being prejudiced, to stop the contested case hearing or a continuation so that others who were in active consultation have the opportunity to be heard. Not in a just as an AHA council advisory, in which there are going to be lineal descendants and developers. That is the issue here as well. So publicly available reports and HCDA related materials already identify Honolulu and Kalaeloa as culturally sensitive areas containing documented cultural sites, habitation areas, trails, sinkholes, bureau concerns, and pre-Western contact bureaus. Petitioner respectfully submits that these unresolved factual and cultural issues require continued consultation and further evidentiary development rather than dismissal. Fourth, petitioner respectfully submits that the procedural deficiencies surrounding today's proceeding further support denial of the recommended order. I really encourage the board to hear what I'm saying, mindful of the fact that it was not even as a courtesy to let me know that this was the time to prepare all of this, in which I've been in good faith preparing for and trying to be heard since I called for the contested case last year and the year before, and the 2.5 years showing up. So if the board agrees to adopt the hearing orders, this shows the public that no matter what you do, money and profit will trump HARs and HRSs and constitutional requirements and procedures. HAR 15-219-53 and HRS 91-11 contemplate opportunity to present argument before a final decision. Again, I'm an adversely affected party, and according to your HRS and HAR, I'm an I'm afforded an opportunity. And to be at least known, because you're trying to dismiss my contested case and the motion to dismiss, and I would have had the opportunity had I not accommodated this agency's request to postpone it because the legislation was active and their bills needed to be heard. So HRS 91-9 and HAR 15-219-50 require reasonable notice regarding the nature of the hearing and issues involved. HRS 91-10 contemplates meaningful opportunity to present evidence, exhibits, rebuttal evidence, and witness testimony necessary for full disclosure of the facts. However, the agenda and public notice did not clearly identify hearing of petitioner's exceptions, what procedures would govern, whether oral argument would be permitted, or whether witnesses and supporting testimony would be allowed prior to final agency action. Petitioner respectfully submits that these procedural deficiencies prejudice preparation and participation by affected parties since January, when the first status hearing was held, and supporting participants. We are now in May 2026. Accordingly, petitioner respectfully requests that the board reject the hearing officer's finding of fact, conclusions of law, and recommend order. I respectfully request that the board reject the hearing officer's findings of fact, conclusion of law, and recommend order to dismiss my contested case called in. Continue the matter that you allow the continuing of the matter, permit completion of consultation and factual development, and allow meaningful participation by lineal descendants in a contested case hearing, cultural practitioners in a contested case hearing, and affected community members in a contested case hearing, not as an aside, not in 3-minute public testimony, before any final agency action is taken. I know you're looking to try to stop me and just, that's enough, repeat it, but if you can repeat inaccuracies that you have recorded for the record on your part, I would like to repeat myself for the record of the truth of the matter and my factual evidence on my part. And I would like for the record that the last thing about the adopted recommendations that you had said that it's premature, that this is what you're suggesting. Again, you guys did this between September public hearing and my contested case, like started like right then, that the cultural consultant that was collecting really important, special, and oftentimes confidential information, or to express and to give that to cultural consultant, that they were dismissed by Kalaeloa, and a new cultural consultant has been assigned. So I want to show for the record the continual obstacles and the inconsistencies and the prejudice and procedural ambiguities and not following their own laws.
Ms. Rojas, I think you've noted your concerns repeatedly in writing and here today. Is there anything else that you want to present?
I would like to present that you allow for the continuance.
We have received, you've asked that multiple times.
Okay.
You've asked.
Okay, you know what? Then let me just go ahead and do this. For the record, September 3rd, 2025, petitioner raised concerns during the HCDA public hearing, requested consultation with lineal descendants, Cultural Bureau, shoreline and customary practice concerns formally raised, contested case concerns initiated. October 2025, HCDA initiated Kapa Akai process. HCDA retained consultants regarding cultural consultation. That consultant is now dismissed and a new consultant is being assigned while we were in active consultation. And he has collected testimonies and sensitive information. HCDA's Kapa Akai analysis was substantially drafted before meaningful consultation occurred and excluded lineal cultural descendants who have previously testified and let it be known their cultural their cultural and lineal connection to this area. So drafted before meeting consultation occur with petitioner later identified lineal descendants. November 2025, HCDA moving forward using October 2025 Kapa'akai analysis. Original analysis relied on limited consultation participants. Additional descendants and cultural participants had not yet fully participated. January 2026, Ulukoa initiated additional consultation efforts connected to the contested case and descendant concerns. HCDI provided Ulukoa incorrect contact information for petitioner, including incorrect email, phone information. Communication and coordination materially delayed. February 19, 2026, Ulukoa had incorrect contact information from HCDA. February 2026, certified letter sent to establish direct communication and continued consultation participation. March 2nd, 2026, certified letter received. First successful direct communication established between petitioner and Ulukoa. March 2026, petitioner immediately began coordinating with lineal descendants, cultural practitioners, and supporting participants. Additional errors came forward. Interviews and consultations scheduling actively underway. Testimony and cultural information actively being collected. March 10 to 15, 2026, major Kona low storm caused statewide disruption. Severe flooding, road closures, power outages, power disruptions, communication issues, and emergency conditions impacted Oahu and other islands. Storm impacts continue long after the event ended. March 20 to 22nd, 2026, additional Kona low system and continuing storm impacts affected scheduling, travel, communications, and participation. Recovery efforts from prior flooding and storm damage remain ongoing. April 2026, consultations still ongoing in good faith. Active coordination with Ulukoa continued. Descendants preparing interviews and testimony. Additional information and cultural concerns still being developed. April 8 to 12, 2026, additional Kona low storm system caused further disruption throughout the consultation period. Continued impacts affected utilities, travel, communications, scheduling, and participation by affected families and descendants. April 8, 2026, HCDA directed Ulukoa to cease interviews and halt consultation process before completion and now have dismissed Ulukoa. Or not April 8, but May 2026. Important legal themes. Consultation was active and ongoing. Additional lineal descendants came forward after original Kapa'akai analysis. HCDA recognized further consultation was necessary and initiated additional consultation through Ulukoa. Delays were caused by incorrect HCDA contact information, multiple Kona low disruptions. Descendants and participants remain in active communication with Ulukoa. Consultation was halted before completion. HCDA should not rely on incomplete consultation as grounds for dismissal when the consultation process itself was interrupted before completion, because that was attempted to be done earlier to dismiss, saying that I was not responding, which was incorrect. The key lines through and just the record demonstrates that consultation was active, ongoing, and producing evidence before HCDA halted the process. HCDA's original Kapa'akai analysis had already been substantially drafted before meaningful consultation occurred, with subsequently identifying the descendants who later came forward during the contested case proceedings. And again, I strongly recommend that the board itself in good faith and to gain and maintain the public trust in HAR and HRSs and contested case proceedings. And that Kama'aina, born and of this place, who stand to protect what has already been decimated, destroyed, desecrated in the most abundant area. Limu management area is no longer. This is the only karst system area in Oahu. I strongly recommend that the board deny and oppose the decision or the adoption of the hearing officer's recommendation to dismiss. Additionally, in all of your board meetings, and before you transferred the land to the city and state, and you discussed it here, the Orty Pond contamination, significant site, tens of thousands of years, contaminated by the Navy. We see cultural sites desecrated and destroyed in the area of development. by the developers. We know the runoff. So all in all to say, to please allow the continuation and for us to adequately and correctly prepare. Since continuous ways and means to stop my right for a contested case and to be heard correctly, to avoid prejudice. Because it's all these meetings that you decide are after the fact. You're saying I'm premature, but everything you always discuss and when we see it, it's after the fact. You guys discussing how it's, no, we're not the right agency to deal with this, contaminate. This is things I was gonna prepare, but this is not my argument, but that's how I like a continuance. I just would like to say that I heard you all say that this is not the agency to best to deal with, and you're short-staffed, first of all, and this is not the agency, you're not adequately prepared to deal with contamination. And yet, I attend board meetings, and you are willing to work with the contaminator, with the Navy, in order.
Ms. Rojas.
But just to be able to use the 18 million, that if they didn't use it, they would lose it by September to
Ms.
upgrade
Rojas, this matter seems peripheral to the conclusion of your.
But this is part of, this is the type of, you're saying it's premature, it's not premature because I see the after effects of the continuation of the decision of this
So,
agency.
Ms. Ross, you keep saying that we said it's premature. The hearings officer that will listen to both sides, three sides of it, said it's premature. You keep saying that we said it's premature. The hearings officer said the petition is premature. Just want you to.
Thank you, Director. Ms. Rojas, once again, is there anything you haven't said
Okay,
that's related to this matter that you'd like to say before concluding your presentation?
right. Yes, I would like to state also for the record that during the hearing, there were status hearings and several status hearings that it was brought up by the agency and the interveners that it was, again, premature. Not only and additionally, the hearing officer stating it's premature, the agency itself and the intervener stating that it's premature, that nothing has been decided yet, thus to dismiss. So all I'm saying, if the case is premature, what is the emphasis to stop and not allow me to present? With adequate notice, following the guidelines and the timelines, I accommodated this agency, and this agency continuously obstructed my ability to have a contested case. And now we're right before square one, we're like back to square one. Let's dismiss this. So just kind of dismissing all of everything I did in good faith to follow your guys' procedure, HARs, HRSs, to have an opportunity to be heard.
Ms. Rojas, you're continuing to repeat the same point that you've made multiple times in this presentation and in your written remarks. Is there anything else you need to say before you conclude your presentation?
So I would just like to conclude that I strongly request a continuance.
We have heard that repeatedly.
And that the board agree to to deny and oppose the adoption of the recommended order to dismiss and allow a continuance.
Okay, thank you for your presentation, Ms. Rojas. You can move back now. And we're going to take a 5-minute recess. I know we've been going for about an hour and a half. So we'll take a 5-minute recess so that people can use the restroom or get a drink of water. And we will reconvene the meeting at 10:35. And when we do reconvene, We'll be welcoming the intervener to make a presentation. Thank you.
And just for the record, at this, I would have known I would have been able to bring all the exhibits and our legal.
Okay, welcome back, members of the board, members of the public. The time is now 10:36 a.m. and the meeting is reconvened. We will move now to ask interveners to make their presentation. Interveners, it's time. Morning.
Morning, Chair Higa, members of the authority, Executive Director Nakamoto, Brian Kang, appearing on behalf of the interveners, the Hunt and Gentry entities, who are either present or online this morning. I wanted to start off, first of all, on briefly addressing some of the procedural issues raised by Ms. Rojas this morning. I think the first general concern, procedural concern that she raised was the agenda or the description of the agenda item this morning, which is, shall the authority adopt hearing officer Rodney K.F. Ching's findings of fact, conclusions of law, and recommended order in the contested case dated April 22nd, 2026, in the matter of Tara Rojas. And I think, you know, Ms. Rojas raised a number of concerns with that because the agenda item does not specifically indicate that her exceptions would be considered in connection with the agenda item. However, as the board is aware, you know, pursuant to law, HRS Chapter 91, as well as the HCDA's own administrative rules, the board is required to consider the entire record with respect to the contested case hearing. And so in order to make a decision on whether to adopt the recommended order issued by the hearings officer, the board does need to consider Ms. Rojas's exception. So, you know, we agree with the Deputy Attorney General's indication that, you know, the agenda item does not need to separately indicate that the exceptions will be considered because by law, the board needs to consider those exceptions. And it is very clear on the record today as well that the board has those exceptions. The chair indicated that the board has exceptions. The executive director went through the exceptions this morning. So it is very clear that the exceptions, Ms. Rojas's exceptions, are before the board, and the board certainly must consider it as part of the record this morning. I'd also like to briefly turn to Ms. Rojas's request for continuance. You know, as the board is also aware, in considering the entire record of the proceeding, the board is required to confine its consideration to the record before the hearings officer. And so to the extent that Ms. Roth is requesting a continuance to allow additional evidence or additional individuals to testify or to provide additional evidence that's outside the record, that continuance should be denied because of the requirement for the board to consider the record in front of the hearings officer. To the extent that Ms. Rojas is indicating that a continuance is warranted because she needs additional time to prepare her argument, clearly there has been sufficient time at this point. You know, this matter was originally scheduled earlier. It was scheduled for today. And Ms. Rojas, I think the record indicates this morning that Ms. Rojas did have an opportunity to present her arguments with respect to her exception. So the request for a continuance should be denied. Turning to the merits of the agenda item, the interveners did file a statement in support of the hearing officer's findings of fact and recommended order. You know, the petitioner raised a number of arguments in her exceptions. Hunt and Gentry agree with the executive director's response and characterization to those exceptions. So we incorporate those by reference. But in addition to that, you know, none of Ms. Rojas's arguments in her exceptions really change, in our view, two dispositive facts with respect to what the hearing officer found. The first fact is that despite numerous opportunities to do so, Ms. Rojas has not cited any specific administrative rule or statute that requires a contested case hearing in this rulemaking proceeding before the board and under these circumstances. That's because there simply is no rule or statute requiring a contested case hearing for consideration of the proposed amended Kalaeloa master planning rules. The second fact that we believe it's important to focus on is that to the extent that Ms. Rojas claims a contested case hearing is required by due process, constitutional due process, it's undisputed that HCDA has not yet made a decision on the proposed Kalaeloa master planning rules and has not issued its written copy analysis. In other words, the board is continuing with its due process. It is continuing to provide due process through the process that it was undertaking and was stopped because of the request for contested case hearing. So, under those facts, it's dispositive because the Hawaii Supreme Court has held that in agency rulemaking procedures such as this one, agencies are required to show that they met their constitutional obligations so that the agency's decision can be evaluated and reviewed. The final decision. And to date, again, HCDA has not made a final decision regarding the proposed amended Kalaeloa master planning rules. So therefore, based on the entire record of the proceeding, the hearing officer properly recommended the dismissal of the petition as a matter of law, and the interveners respectfully request that the board adopt that recommended decision in its entirety. Thank you very much.
Thank you, great. Thank you to council for the interveners. We will now move to public testimony. The HCDA has received 2 pieces of testimony, both in opposition, and those testimonies have been distributed to the board members. We have some people pre-signed up to provide testimony. Mr. Kang, that is your testimony, or do you need separate testimony?
Yes, I apologize. Thank you very much.
Okay, thank you. So we'll move to the first person registered to provide testimony on this agenda item is Hivahina Kaheaku Rodenhurst, representing Hui Kuleana o Ko Hawaii Pai Aina Ma Kalaeloa.
Could I request that she go before me because she has to take her son to the.
Sure. Is that sorry, what is your name? Ahapuhi. Sure.
Thank you.
Please go ahead.
Thank you.
Yes,
Thank you for waiting.
yeah. Everybody got their coffee?
3 minutes.
All right, good morning. My name is Avapui Kalauli, and I'm presenting today on behalf of support of the case to continue. I think that the due process is important, specifically because my last name is in the EIS. So there's been many EISs that's been conducted in the Honouliuli Ahupua'a. My family is also Konohikis, identified by the state of Hawaii. We actually won our royal patent in 1992. So it is in the Bureau of Conveyance. It's registered. That was January 24th, 1992. And that was represented by Native Legal Corporation. So my family, the Kalauli family, we are Kalauli Ka'ava Kalae'kula. Just a couple days ago, I did a testimony for UH, and Governor Neil Abercrombie also recognizes my last name as my family did do security for Governor Linda Lingle. So we've been very instrumental in the process as far as trying to work with the state. We own a lot of lands, 84 ahupua'a. Unfortunately, we don't have all 84 ahupua'a that we're allowed to have title and access to. So one of the things I think is important is there hasn't ever been a situation where our family has had an opportunity to work collaboratively with a developer or with a development project. And I think with the contested case, just a little bit of background, I've actually been following Tara behind the scenes because I'm in a lot of land court cases for my family. And so when she got the contested case, I actually was right behind her where I told her, I don't even know how you did it because we've been trying for a long time. Just more history and background, I actually paddled for Ewa Pu'uloa, so I'm very familiar with the Huakale Foundation. I know the Sorrells personally. I also know about that particular spring that connects to Kukaniloko because my family runs the waterway of Waiahole Ditch from Waiahole, Waikane, Kahalu'u, all the way over through Mililani, Vahiava, coming down into Honouliuli to West Lock. So I am very familiar as far as what my water rights are as far as a descendant. And I still carry the last name. I'm a Kalauli, still yet through and through. And for me, it's just, I feel like when we do these situations, we become enemies. You're on one side, we're on the other side, we're screaming and yelling at you, and trust me, I'm sure I've screamed and yelled more times than I apologize, but for me, I just coming to today to just acknowledge, like I said, 84 Ahupua'a, that's my family's patents. It's not something that just gets tousled over. And I'm not saying it's your fault or anybody else's fault, but I do request that we have at least some procedural hearing. And you know what? If you win the hearing, high five. I'll pat you on the back. I love winning court cases as well, and I enjoy that win. To me, I ask humbly that my name is in that EIS by Kumupona Associates, which is 776 pages, over 18 times. And I think just from recognizing what I'm making a statement today, I just would request that procedurally, just give us our day. That's it. We're not asking for anything other than we worked really hard on this. I can tell you that from September. We've worked really, really hard on this. And we do not have a par license or an attorney degree or anything. And we've just been trying to follow the civil procedures and just so we can have our voices heard. And that's all. That's all we're asking. And I know my 3 minutes is up, but then I also put Hualalai in there. And this is the Mo'olelo. I know the last time we kind of got into it because I said he's 3 weeks old, he can't speak. The point I'm making is when the Kalaeloa master plan was created in 2006, I was 19. I had no idea what was going on. The only thing I knew is my uncle Levi Kalauli Ka'alva had land out in Waimanalo that they fought for and they won. And our Governor Waihe'e, who's our cousin, by the way, is our cousin. I have the brother's phone number right there in my phone. They had a situation where they won land. That's all I knew in 2006. So I wasn't trying to be funny, maybe a little bit, but I was just trying to show that procedurally there are heirs like my son, 6 weeks old, that are represented here, but not represented. You know what I mean? So for me, it's just, we have to, not that any of us is responsible for making that procedure known, but this is an administrative hearing, which gives us the opportunity to make that procedure known. And the one thing I want to say is nobody's ever asked me if I would be willing to work with a developer on title issue, on development. Like, we should be the developer. It's our title. We should be the developer. We should be the ones getting paid for it. We should be the decision makers. And the reason I bring this up is I was a foster child, ironically, and I was raised by the owners of Associated Steel. They built H3, Tripler. They built the railway, first 2 stages, and we sold it. And now we just run the cranes. And a lot of it was because of corruption. My dad used to order work stop orders. My dad's a good man. Everybody who hears his name knows my daddy is a good man. And it's because he had a Hawaiian in his house. 2 girls. I'm almost full Hawaiian. I have nothing else to represent but this Pai'aina. And these are my cousins, and they live in the Pu'uhonua. They live there where their uncle, put a roof over their head, and that's the best we could do because we don't have a voice for my 84 Ahupua'a, but we have something. And so that's all I wanted to testify. And Hualalai. And thank you for being quiet, Hualalai.
Thank you.
Thank you very much. I appreciate it.
Thank you, Ms. Kalali.
Okay, let's go to the doctor. Have a great day.
You as well. We'll welcome the next testifier, Hivahina Kaheaku Rodenhurst.
Morning begins.
Give me 1 moment, please. So my name is Hibahiba Kaheaku Rodenhurst, and I appear today under special appearance, continuing objection and preservations of rights as a national of Kauai Aina, a Kanaka Maoli descendant, and supporting participant or petitioner in this matter. I support petitioner's request for continuance, clarification of procedures, amendments of the agenda and public notice, and preservations of rights prior to any final board actions. And before I continue, I would like to just present to you what it says in the law so that we can all be on the same page. Because from my understanding, this is not happening with the agenda that was presented today. So according to HRS, give me 1 second. According to HRS 91-9, contested cases, notice, hearings, records. Subject to section 91-8.5, in any contested case, all parties shall be afforded an opportunity for hearing after reasonable notice. B, the notice shall include a statement of the date, time, place, and nature of hearing. The legal authority, two, the legal authority under which the hearing is being held. 3, the particular sections of the statutes and rules involved. 4, an explicit statement in plain language of the issues involved and the facts alleged by the agency in support thereof. And then it continues that provided if the agency is unable to state such issues and facts in detail at the time that the notice is served, the initial notice may be limited to a statement of the issues involved, and thereafter, upon application, a bill of particulars shall be furnished. The reason we're asking for the continuance, again, as from when I saw this agenda and reading this rule right here, it says plain language. There's a memorandum attached, and nowhere in that memorandum does it mention that her exceptions is being heard. For us, what it looked like is that you're just covering up the exceptions. It's not a part of like a public notice, and that you guys are moving forward to hear the vote on the dismissal. And that's why it was unclear to us. Then we did, okay, first off, I want to point out that I thought that this was going to happen on June 3rd, this hearing. It was not clear to me that this was going to happen this day. So on May 21st, I was on vacation with my family. I had to cut my vacation short, and I couldn't go on the trip with them because this was brought forward. And so I said, okay, let's look into it. After reviewing it, we're like, hey, are we having our hearing or not? So that part right there, it says that it has to be clear for us to have this understanding what the issues that are being discussed. Now, I understand that you guys are saying that you guys receive it, you guys are reviewing it, but we sent an email asking Craig if our exceptions would be heard today. And he could have simply replied to us saying, yes, it is, be prepared. Or yeah, he could have just said yes. Instead, he just said that the notice that the hearing would continue as noticed. So as you can see, again, we're not getting that clarity, which is again how I was stating that all of the participants, right, that who want to be here, who want to testify, are not being given the opportunity and the proper notice to be here today. So I also appear. Okay, I'm sorry. So I support petitioner's request for continuance, clarification of procedures, amendment of the agenda and public notice, and preservation of rights prior to any final board action. And I oppose any final decision made due to the lack of proper notice to not only the petitioner, but to the public itself. And I oppose and ask the HCDA hearing officer, I oppose the hearing officer's finding facts and conclusions of laws and recommended order and ask that it be denied. I also appear on behalf of affected descendants, heirs, cultural practitioners, and supporting families connected to Honouliuli and Kalaeloa who could not reasonably be present today because the agenda and public notice failed to identify that petitioners' timely filed exceptions would formally be heard prior to agency's action. The notice did not identify the exceptions, did not state oral arguments would occur, and did not clarify whether witness testimony exhibits, title evidence, declaration, rebuttal evidence, or supporting testimonies would be permitted regarding the exceptions for today. As a result, affected defendants and participants could not reasonably determine whether they needed to appear prepared for participation in a contested case hearing on the exceptions. For the record, I place the heirs of Kekuana Oa, the Kane Ohana, Kaleohana Ohana, Kahumoku Ohana, Hicks Ohana, and Kahau Ohana into the record as affected descendant families connected to Honouliuli and Kalaeloa, while reserving the right to supplement additional names, genealogy, and title evidence as the contested case hearing, consultation, and factual development continue. And I also want to put on the record that our preliminary title report, patent and title examiner was not able to be present today because she is also in court with the Kane Ohana. So that was a part of our exceptions, our preliminary title report, which is disputing lands. I testify that I am a Kanaka Maoli descendant with genealogical and historical ties connected to lands within Honouliuli, including royal patent interests, ancestral connections, and unresolved historical title concerns associated with the district. I myself, when this thing was created, was also in high school. I went to Kapolei Middle School, and I was not aware of this Kalaeloa board meeting. So now, as I'm coming forward today, I feel that my rights should be heard.
Ms. Kahiaku wrote in hers, we've already allowed you about 6 minutes to testify. I'm going to ask you to conclude, but my invitation to you, it seems like your reading remarks is you can submit those to the written testimony. You still can for this meeting. Speaking for myself and I think representing the board members, we read every piece of testimony and no matter how long the testimony is. And that's one of the best ways to introduce lengthy arguments into the meeting. One of the reasons we keep the spoken testimony to 3 minutes is out of respect for members of the public, your time or Avapuhi's time, so that these meetings can allow all the arguments to be surfaced without necessarily taking everyone's whole day. And I understand that 3 minutes is not a lot of time to testify. So I allowed you 6, but if you could, conclude and please submit your written testimony, we will read it.
Okay, then first off, I just would like to testify that Tara did inform me as soon as she heard from Ulukoa, and that the 3 Kona lows severely affected my family. Our family was underwater and we're totally tired and exhausted from trying to just protect our home to be able to reach out to Ulukoa and continue with our consultation. So I'm putting it on the record that I was in contact with him. I told him that after the after the Kona lows, the last Kona lows that happened, if we could have consultation and continue. And my consultation was cut short because of it being stopped. I also want to state for the record that I am also aware, and it's also, I know that it's in part of the exceptions, and I've seen the email myself from Ulukoa where he states that he did reach out to Tara via email and it was the wrong email address, that it got kicked back to him and that the contact information. And so it's not that she was not in good faith participating, but from my own observation as well and from my contact with Ulukoa as well, he stated that, I mean, it's in the record. So please review that. The other thing I want to say that I heard earlier that it said HD. Yeah.
I'm really going to have to just ask you to conclude this remarks. I know you're also scheduled to testify on agenda item 2, so there will be additional time there. But it's really out of respect for everyone else who is here to testify or who has business before the authority. Not just on this agenda item, but on the, I'm sorry, I'm not asking, I'm sort of telling you, you have to conclude your testimony.
Okay, well,
and then we're going to take the next.
I just have some things that was said and that I need to just like say. So he stated that there's not this dispositive motions that were, or dispositive statements that was stated, but I believe the dispute to title to lands and the fact that this November 17 vote was to approve amendments. So how can you approve amendments if we're not actively a part of it? So I think a consultation process is proper so that all of us can put in the information and share it with you in a proper timing, because it's not enough time. As you can see, it's not enough time for me to share all my concerns. I have all of these documents printed out and I understand what you're saying, but it's not enough time for me to say what I need to say. Therefore, what I'm trying to also say to you is that the contested case hearing should continue because of this specific reason, so that we can provide you with all the information so that you can make an accurate finding.
Your concern has been heard, and I must ask you politely to return to your seat so we can hear the next testifier.
Thank you.
The next testifier is Hualalai Kuamo'o Kalauli. Oh, sorry, that was Abukuli's son. The next testifier is Po'okela Craig Rodenhurst.
Morning.
So overall, only Po'okela Craig Rodenhurst, son of A'opoha Kuku. And my father is Lucky. And my mother is the daughter of Kekanikalo Kawaile, the ancient god, who created a lot of the gods there in Honouliuli of the family and the royal patent of Miriam Kekaunohi. I come from a Konohiki bloodline, a Li'i bloodline, all these tutus that is across the street, Lunalilo, that's all my family. You're looking at one royal heir. You're looking at one Ho'oilina, an heir. I don't go into nobody's probates and administer their probates without talking to the heirs who have rights, titles, and interests. These lands are very sacred to us, and yet we keep it on the low. For 132, 142 years, there has been a great injustice towards my family. I am an heir of Miriam Kekaunohi. If you don't know that name, that's the royal patent for 43,250 acres of Honouliuli. I am responsible for the ancients and the gods of that area, as well as Makapu and the ancients of where I reside right now. I live. I don't live in the state of Hawaii. I don't live in the territory of Hawaii. I don't live in the Republic of Hawaii. And I don't live in the provisional government. I live in Ko Hawaii Pai'aina. That's the name of my country. I come by special appearance to come before you guys. Because we need to not only be heard, we need to be considered. And it is improper, spiritually, you are guilty, spiritually, physically, for not the inclusion of us. Because the HRS 172-11, HRS 172-11 already puts us in the game, in this so-called political game. We will be considered. I'm not saying that you guys are the answer for everything of the heirs, but when you look at what has been presented, evidentially, there is a break of title in the probate. It does not exclude heirs like me to these lands. Yet, the developers, you're authorizing developers to develop lands that belongeth to my family by a royal patent sealed by the king's decree and the prime minister, the Kodahiki, and 3 judges. It is a court order beyond what you can fathom. So I end here because this is what I woke up with, that the ancients of these lands, to really know these lands, and the Kino, Kealopono does not answer for me. That may be your guys' procedure. Kealopono is not an heir to this land. Miriam Kekaunohi is my family. Miriam Kekaunohi is my family. Kali'i Ahonui is my family. Ha'alalea is my family. They are all linked to Kamehamehas. That is my family. Now, the ancients woke me up this morning because I didn't want to come. Because I knew exactly what was going to happen. How the procedure. This is not my first time seeing this. I see this all the time. For every good thing, there's a consequence. For every wrong decision, there's a consequence. But most of all, with these lands that you guys are managing or making authority decisions over, because the land has a chant and it has a curse. It do has a curse.
Can you summarize your?
And I will summarize of what I woke up with a chant because I represent these gods here. I represent the gods of this country. And the chant they woke me up is this. And this goes to pertain to Honolulu. Te naua I te ana na kua o ta Honolulu. E mama I te ana na kua I to oilina. He mo I ke ana na kau ta ame hame hauna no kua ua kuli. E taua I ke ana na kau I ke ana na kua au te au maui. Hoi tēnā nei te ia kama mo ko I te ama mo e ama makana no ko I te au mahana. Ai ama makana no ko I te hana no ko I te au I palalo hoi ke ana na I nei. Au e ala I te ana na kau te ahana. Au e ala I ke ana na I kau oha. Kau oha I ke ama mo I ke ohana na ohana I tēnei. E hewa no I ke nei. E hewa no I ke ama mo o konu no ko o te au I te hana I te. I ke nau I ke mau. E ho'oponopono I ke ia nei. E ho'oponopono I ke ia ina ho'oilina. Ko amama ko akamau I tenana I kamau I ke alala kanana ka o te hawa I te nei. I kai luna. I makai kamana ko oe hanana I ke anana ko o ke ho'ona. E nana I ke nana I ke mama I kolu I ko onana ko I te hawi I ke ina ina. Ia naina ia ko onana ko I ke anana kuliana. E kuliana ina ho'onana e honini ka moko ai ho'olina. O e hono uli uli. E ho'olohe ia oi. E ho'olohe ia oi. E makawai ana oi. E palapala sila nui. E palapala kau oha. Ai ai kanei probata. We cannot, this is a breaking title. This is a dispute of a broken chain in title.
Thank you, Mr. Craig.
This is what they told me to chant for you guys.
Mr. Craig Rodenhurst.
No, I'm finishing here. I'm finishing here.
Okay.
This is what they told me to chant for you guys. Because we have an ancient kuliana. I am a kaula, not a kahuna. A kaula is an umbilical cord attached to the ancients that
Okay,
is
Mr.
attached
Craig
to this
Rodenhurst,
land.
I'm gonna have to ask you to return to your chair. Thank you for your
Yeah.
testimony.
We will be considered the ho'olina. Yeah. Look at the probate. You're authorizing things.
Okay.
You're authorizing things that is incorrect.
Do we have anyone else online or present wishing to provide testimony? Any present online?
Chair.
Okay. Any in person wishing to provide testimony?
I'm petitioner, but I'm also public, right?
You are also able to testify if you wish, Ms. Rojas. You may have 3 minutes and we will strictly enforce it
Yeah.
since you have had much
Yeah.
time to speak today.
Aloha Tara Rojas. I really hope you understand that the procedures that you notice it's not full, there is nobody else, just right now somebody wants to testify. But the fact that you're gonna interrupt and leave just to fulfill these procedure rules that we're calling out, that you're not even following the procedure rules. That continuous control and disrespect is why we need the continuance for contested case, because this limited interaction is the reason that we're at where we're at now. That type of disrespect, let's just finish this. Because you went over the 3 minutes, who else is there? Who else do you want to hear from? Other than Ali'i Air of this place, we call home, if we're not of Coco, we are visitors, we are allies. We have Kuleana to not overstep those of this place. You're there because you have to fulfill the mission and vision of HCDA. When there's errors or when things go through, It's just, oops, sorry. Oh, let's talk about it. Oh, we don't have enough people. Oh, we didn't have enough money. Oh, we're not the right agency. Versus the Kanaka of this land, before this development, they knew and had the Ike and have the Ike to manage the land properly, so it's abundant for all. Profit over people is not the way. Rules and procedures that can be broken when and at will versus rules and procedures and spiritual of Hawaii. Thus, we need a continuance to be heard correctly and with respect. There's much more I can say. I'm gonna leave it at, I did not want to come up after that, but because I saw the disrespect, I had to say something. And thus, we need the continuance. Mahalo.
Thank you for your testimony, Ms. Dorhas. There is someone online wishing to provide testimony. This is the Kekuanawa Foundation CEO. You could unmute yourself. They should be enabling you to testify right now. Kekuanawa, you should be able to unmute yourself on the Zoom.
She's unmuted or she, so they just.
Your account is unmuted, so I don't know if your microphone is malfunctioning.
Please proceed. Maybe we can test.
Yeah, there you go. I'll put you up.
Okay.
Okay, yeah.
3 minutes.
Thank you. We can hear you.
Okay, great. Aloha. Aloha board members. I am the direct descendant of Kekuanaoa, Matayo, Kolohiki, of Honouliuli. I am his 6th generation great-granddaughter who still holds the Konohiki title, right, and interest to his royal patent lands. Sorry, I'm speaking slow just because I want to make sure it gets on the record. I am requesting that the meeting notice on your agenda be corrected as it failed, to properly indicate presentment on exceptions. Due to the due process of the law, there was no due process of the law by failure of prompt and adequate notice to those who need to give a statement. I preserve all my rights without prejudice. I oppose the decision of any hearings officer due to their misrepresentation of facts, which would, by definition, be fraud and concealment of facts. In contract and commercial law, concealment of fraud and coercion refers to the intentional hiding of material facts to trick someone combined with threats of unlawful pressure to force them into an agreement. Ulukoa collected statements from the lineal heirs and Konohiki who hold a cultural, equitable interest into Eva. He was removed from Kapa'akai analysis for giving lineal heirs space to speak. I am also related to Erlene Brady Eaton, who has been recognized in Eva and Pu'uloa region, including areas tied to Honouliuli. She was known as the documenting kupuna for Mo'olelo and Wahikana burial landscapes. They also, my auntie, had provided family ancestry and upbringing in Pu'uloa. I'm very much aware of Huakale's foundation connection to Eva. My grandmother is a Brady. We are the same ohana. Aside from Kupuna Eatons and the Brady's connection to Eva, by far Konohiki right and interest supersedes anything else out there. The failure to exercise the Kapa'akai analysis and our due right in process of the law. HCDA has failed to honor the Kapa'akai analysis. That is a failure of due process. That is a constitutional violation for us to be able to put on the record the ancestral and cultural lineal connections that we hold to this moku. HCDA has continually thwarted the evidence, hid representation of heirs, and removed individuals to complete the Kapa'akai analysis. You are operating under the public law for the land trust, the public land trust doctrine. And you are operating as an agent under the state of Hawaii to facilitate that interest.
Ms. Kekuanawa, I'm gonna have to ask you to summarize your testimony, please.
Yep, fine. Or interest holders. You have been presented with heirs and interest holders who have the right under probate. You are operating under probate law. You are in the probate of my family. You are in the probate of Kekauanohi. You are operating under the probate without failure to allow the heirs to provide their testimony and their right to steward our own interests.
Okay, Ms. Kekuanawa, we have received your testimony. If you have further remarks, we invite you to submit them in written form. Thank you. Thank you. Any persons present or online otherwise wishing to provide testimony? Okay. Seeing none online or in person, we will close public testimony and move to questions or comments from members before we look for a motion. Members, any comments or questions? Member Evans, did you have a question?
Yes, thank you, Chair. I have a question in regard to whether Chapter 91 regarding contested case, whether adoption of rules, which requires public hearings, which have been provided, then allows a contested case hearing petition to be considered under that particular legal framework.
Is this a question for our Deputy's Attorney General?
Whoever could answer.
Yeah. Kelly, are you able to answer Member Evans' question?
Yes, so anyone can submit a petition for a contested case at any time and on any issue.
Okay, but is it I see. Okay, thank you very much. I appreciate the response, Chair.
Thank you, Member Evans. Members, any other comments or questions? Seeing none. Members, is there a motion for the authority to adopt hearing officer Rodney K.F. Ching's findings of fact, conclusions of law, and recommended order in the contested case dated April 22nd, 2026 in the matter of Taro Rojas versus Hawaii Community Development Authority, contested case hearing 2025-001, which is attached to the staff report as Exhibit A. Do I hear such a motion?
Is that what the corrections Craig had mentioned?
Yes, with the correction to the date on page 2 that Craig mentioned. So rather than reading April 25th, 2026, it would read April 15th, 2026. Do I hear such a motion?
So
Moved by Member Streitz. Member Evans, is that a second?
yes.
Seconded by Member Evans. Thank you. So before we we'll have discussion, and then we will have the members verbally affirm that they have reviewed the record before we take any vote. Members, is there any further discussion on the motion? Member Streitz.
Yeah, I appreciate the petitioner and all the testifiers providing their input on this, and in the request to have a continuance. I think it's pretty clear that the conclusion in this, and that this is not preventing such an occurrence in the future, just at this point in time, saying that it wouldn't be, I guess, the correct point to take up the matter. Following any action that occurs, then that would provide another opportunity.
Thank you, Member Straits. Members, any other comments or questions? Okay. Seeing none, a motion has been moved by Member Straits and seconded by Member Evans. Before we take a vote, board members, please verbally affirm that each of you have personally reviewed and considered a copy of the entire record, which includes but is not limited to exhibits and written submissions by the parties and the hearing officer's recommended findings of fact, conclusions of law, and decision and order. I so affirm. Vice Chair Ishii is excused. Secretary Lidstone.
Aye.
Thank you. Member Miranda Johnson.
Yes.
Thank you. Member Anderson.
Yes.
Thank you. Member Evans.
Yes.
Thank you. Member Strides.
Yes.
Thank you. Member Duvashel.
Yes.
Thank you. And Member Gordner.
Yes.
Okay, so we have 8 present, all of whom have affirmed that they've reviewed the record. I will now ask Craig to take the roll call vote on the motion moved by Member Strides and seconded by Member Evans.
Thank you, Chair. On the motion made by Member Strites and seconded by Member Evans. Member Strites.
Yes.
Member Evans.
Aye.
Secretary Lidstone.
Aye.
Member Miranda Johnson.
Yes.
Member Anderson.
Yes.
Member Duvashel.
Yes.
Member Gordner.
Yes.
And Chair.
Yes.
Motion passes, Chair.
Okay, motion passes with 8 yes votes, one excused, no abstentions. Moving next to the agenda item second agenda item, shall the authority authorize the executive director to deny Hui Kuleana Oka Hawaii Pai Aina Ma Kalaeloa's petition for a contested case hearing, docket number to be determined, filed on March 31st, 2026 with the Hawaii Community Development Authority, related to the Hawaii Community Development Authority's April 1st, 2026 agenda item number 3-3.2. Consider approving pursuant to the findings of fact, conclusions of law, and decision and order dated January 7th, 2026 for application number KAL 25010, the reserved housing unit pricing and supporting analyses for increment 4 of Ka'ulu by Gentry, located on parcel TMKs 1911193 and I think various. And 1911198 in the Kalaeloa Community Development District, 911101 Franklin D. Roosevelt Avenue. Mr. Craig Nakamoto, Executive Director, will now present the staff report.
Thank you, Chair. Staff report and recommendation is included in packet 2 of your, in tab 2 of your packet. The staff, along with our Deputy Attorneys General, has reviewed the request. It's not something we take lightly or cavalierly. Consulted, and we're recommending denying the petition for the following reasons. On the agenda item, which was the pricing, this petition has not identified a law or rule which affords the petitioner's right to a contested case hearing prior to the adoption of reserve housing prices for increment 4 in the Ka'ulu Gentry project. Number 2, with respect to the master plan, HER section 15-219-46 provides as follows. A contested case shall commence upon the filing of a petition for permitted relief with the authority within 30 days of the action or decision for which the contested case hearing is sought, unquote. The Kalaeloa board has not, as you've heard before, has not taken any action or made any decision on the proposed amendments to the Kalaeloa Community District Master Plan. Accordingly, there is no HCD action or decision for the petitioners to challenge. Therefore, we recommend denying the petition.
Thank you, Director Nakamoto. Members, are there any questions or comments on this agenda item?
Chair?
Member Evans.
This might be a question for our Deputy AGs. Should an action be taken on the substance of the let's see, Gentry's request for approval by the Kalaeloa Board of the reserved housing pricing for increment 4 of Ka'ulu by Gentry, would the motion for a contested case hearing then be something that the the Hui could then file, or would that be an appeal to our judicial system? Is it, what would be the action that the Hui could take?
Thank you, Member Evans. I'm gonna ask Kevin Tong, our Deputy Attorney General, to weigh in if he can.
Yeah, sorry, Mary Alice, what exactly is your question? What's the correct process?
Yeah.
I think,
Yeah.
Member Evans, if I have it correct, the question, Kevin, is if the board were to move forward and adopt the action item, which is the reserved housing unit pricing for Ka'ulu, would the Hui have recourse to file a contested case hearing after that decision has been made? Member Evans, am I representing your question correctly?
Correct. Or would an appeal to the judiciary be the action that the Hui could take? Just wanting clarification on what their legal process could be.
Yeah, they could submit a petition, or they could take the path to the courts. That's up to them.
Okay.
It wouldn't be an appeal. It would be it'd be a different lawsuit.
Member Evans, does that answer your question?
Yes. Thank you very much. Thank you, Chair. Thank you, Kevin.
Thank you, Member Evans. Members, any other comments or questions? Seeing none, we will go to public testimony. We have received 3 pieces of testimony on this agenda item, 1 in support and 2 in opposition, all of which have been distributed to board members. We have some people pre-signed up to provide testimony on agenda item number 2. The first of which is Hivahina Kaheaku Rodenhurst.
Okay, I'm here, so I appear here under special appearance, continuing and objecting and preserving my right as a Kanakamoli, as the alaka'i for Hui Kuleana o Kohawaipai Aina Ma Kalaeloa. And on behalf of the affected descendants, heirs, and supporting families connected to the Honouli'uli and Kalaeloa areas. At the outset, I object to the authorities proceeding towards denial of the petition for contested case under the present circumstances, and request continuance of this matter so that the lineal descendants, heirs, and cultural practitioners and supporting participants who are a part of the Hui Kuleana o Kohawaipai Aina Ma Kalaeloa could be here present. And we also put it on notice that we had conflicting schedules where they're in court today in Kaneohe District Court. So we're asking for a continuance for this hearing. Also, I just want to put it on the record that there's multiple affected descendants and participants who have lineal ties to this land. I know that we weren't able to proceed with a contested case, so we can't provide the evidence that we need addressing title to this property, but it has been presented, partially it has been presented in Tara Rojas's contested case. I also want to put on the record that our we did file so sorry, it's like we filed like a supplement to preserve our position, and I was hoping that you guys received it today via email. Okay, so I would like that to be on the record, included as well. And I do want to say that this is not a premature matter, because you guys are talking about pricing of properties. There's already been development that's already been started within these areas that affect lineal descendants. And so we don't feel like it is premature to address this in a contested case process when we're addressing title to lands. And we believe that this is an appropriate time to bring this forward because the process has already started. There's been lands that's actually my family's kuleanas that actually has been covered. So that is why we have hui'd up to come forward and bring forth our claims. And we're asking that you guys deny this denial and push for allowing us to have a contested case. Yeah, so the other thing that I also wanna identify too is that under the HARs and under the the HAR chapter 15-219 and the HRS chapter 91, it does not specifically state that there's a specific time when we have to request a contested case hearing. So whether it's regarding after approval is made or when you're talking about amendments, you guys are trying to like box this into a box, but it doesn't necessarily say that this approval has to happen before we can bring forth a contested case.
I'm gonna have to ask you to conclude your remarks.
Okay, so in conclusion, we're asking for a continuance so that everyone can be here in person to speak their own, and that our situation is not just because we're just trying to push it off. They had important stuff such as court.
Thank you. Thank you for your testimony. I don't believe we have anyone else pre-signed up to testify.
Okay.
Mr. King.
Morning again, Chair, members, Executive Director Nakamoto. Gentry did submit testimony on this agenda item. Just a couple of brief points. As the board is aware, the petition for contested case hearing was submitted in connection with the board's consideration of Gentry's request on the reserve housing pricing for phase or increment 4 of the Kalaeloa project. The project has been the subject of 2 prior contested case hearings under the current Kalaeloa master plan and rules. And that's important because the petition refers to the proposed amended Kalaeloa master plan and raises concerns about future development in relation to those proposed rules, as well as the proposed master plan. And so factually, the petition does not apply to the Kalaeloa project because it was entitled under the existing master plan and rules. So on that basis alone, the petition should be denied. Even assuming the petition could be construed to apply to this particular project, there is no rule or statute that contemplates a contested case hearing for a reserve housing pricing request or a request that's incidental to a project that has already been entitled and permitted under the rules. The petitioners did have the full opportunity and due process to participate in the Kalaeloa contested case hearings. And again, there were 2 of them. So there was ample due process with respect to the project itself and the entitlement. And finally, to the extent that there's concerns about the Kapa'akai analysis with respect to the Gentry project, again, through both contested case hearings, the Kapa'akai analysis was conducted. The board made findings with respect to Kapa'akai with respect to this project, which was again under the existing master plan and rules. And finally, to the extent that the petition seeks a contested case hearing regarding the board's consideration of the proposed master plan, Gentry just incorporates by reference its position with respect to the Tower House matter. Thank you very much.
Thank you. Thank you for your testimony, Mr. Kang. We have someone online wishing to provide testimony. This is the Kekuanaua Foundation account. You should be able to unmute yourself, but if we have difficulties, maybe we could call the person again. Sorry, Ms. Kahiaku Rodenhurst, are you able to call in Kekuanaua Foundation? I think they're still having difficulty with Zoom.
Okay.
Thank you.
Here we go.
Thank you.
Hello.
Hello.
CEO Foundation, speaking on behalf of the lineal descendant of the Royal Highness Konahiki Matayo Kekuanaua. I just wanted to state on the record that the contested case hearing is premature. And yet, even though it was approved, the master plan is too late after the fact. Meaning, you may say you have a contested case and the Kapa'akai analysis was done and the contested case hearing was cleared. But there's other heirs who weren't notified. And if you folks are operating out of the probate trust and the public land trust, then you're already aware, or the attorney general should be aware, that you have royal heirs to these bloodlines who were not made notice to. And Craig and the rest of the HCDA board, you guys were aware of myself and Tijuana descendant, because I stated this in many meetings before. We absolutely have right in regards to this case, as far as requesting a contested case hearing, because there's so much issues surrounding title. This is a public land doctrine issue that you guys are operating out of. Those public land doctrines are held in probate. Those probate records are still open, and there are still lineal descendants who hold equitable interest in that probate. We are those people. We have a right for contested case hearing on the mere fact that title is an issue. This is a called a title issue. How can you proceed and regulatorily indicate that you are the only people who have authority to make these decisions? HCDA is not the only authority to make these decisions. The lineal heirs and direct descendants of these probates, we have right to that portion of speaking for the stewardship of these lands. HCDA is not the only, they are not the only representation for stewardship. And the failure to include the lineal heirs and the blocking of the Kapa'akai analysis in this manner, you may say Kapa'akai analysis was done and an EIS was done. Okay, great. But let's bring you up to speed with the public land doctrine. You just came upon your positions. Were you aware that under the public land doctrine, you're operating out of probates that are still open, probates that still have heirs? These heirs have interest. We are here to present that interest. So therefore, we have a right to the contested case right now. We're being blocked to make a contested case so that you can move forward. And that's a failure of due process of the law. Period. Mahalo for your time.
Thank you.
Thank you for your testimony. Is there anyone else in person or online wishing to provide testimony on this agenda item? Ms. Rojas. Ms. Rojas, could you please provide your testimony not to exceed 3 minutes?
So what I was just asking the developer is if I could just borrow and if he could just put his paperwork there. Why? Because it seems if you're not here, you don't feel the energy. So as I was sitting there in the audience, yeah, just kind of listening to when the intervener, the developers come up in these type of meetings. So imagine, this is not mine, but this is the developers, yeah? So can you imagine this? I'm here with my proposal, or let's just deny this contested case, yeah? There's a different energy that I get from even being as the attendee, that they're looked at as the authority because they're aligned with your guys's, yeah, value and mission. So if I was sitting there and seeing him with this, okay, well, according to this, and even if this says that, you know, it's premature, and then this was, you know, grandfathered in, there was already 2 other contested cases, but look, we're still talking about the other development and increasing or whatever the price is, yeah, accommodation. And it's like, I feel the energy, you guys are just intent to listen. Because whether it's to deny this contested case, or whether developers come and they're like, this is what we're gonna do. I wanna develop, let's just do this. And because that's what you all want, you're gonna actively and attentively listen. Versus you come on this side, yeah, now I'm me. Or you just heard the lineal heir, you just heard Kipuana Foundation. We come here, it's automatically Yeah, let's just get through it. Let's listen to the hour testimony that she didn't know she was gonna have to prepare. That's why she's asking for continuance. Let's just listen to this 3 minutes. Yep, I'm gonna allow you a little more, but you gotta finish, you gotta wrap up. Knowing that there's nobody else here, that we're the only ones that come. It's a different, you guys disengage. And this is the continuance. So if you're saying premature, I've seen and I've heard how there is no T1 transit zone. There is no natural zone, untouched zone in the Kalaeloa master plan or in Kalaeloa area because of this continuous development. So I've seen the progress, thus I call a contested case. But yet we come here with all the facts of this place. Hawaii is Hawaii because of Hawaiians. Your development doesn't allow maybe those who are of the mindset to just develop, and they, like how everybody said, we grew up not knowing this. Do you see this place, Phil? There's already a prejudice when you come here.
Please
So
summarize.
I'm gonna summarize this. What is it that we need to say? What is the key word, the key statute, the right timing before or after when it's all developed, there's no untouched development? Because that's what this mindset of this government is. No land built, nothing built, let's develop it instead of taking care of it.
Okay, thank you,
Yeah.
Ms. Rojas.
So-
I'm gonna ask you to return to your chair.
Just the injustice. What is it that we need to say for you to allow?
Thank you, Ms. Rojas, for your testimony. Do we have any other people present or online wishing to provide testimony on this agenda item? I think we have one online. Online
No.
Oh, sorry. This is just a procedural note that Secretary Lidstone left the meeting at 11:40 a.m. Seeing no further public testimony,
There's one more person, Maleka Higgs.
is he on the Zoom? Okay, we're not gonna do any more phone call-ins for people who are not on the Zoom. This meeting was noticed, including all the ways to participate. And we are going to move now to close public testimony on this agenda item. Members, do we have any questions or comments before we look for a motion to approve? Okay, seeing none, is there a motion for the authority to authorize the executive director to deny Hui Kuleana o ko Hawaii Pai'aina Ma Kalaeloa's petition for a contested case hearing, docket number to be determined, filed on March 31st, 2026, with the Hawaii Community Development Authority related to the Hawaii Community Development Authority's April 1st, 2026 agenda item 3.2. Do I hear such a motion?
So moved.
Moved by member Strites, and do I hear a second?
Second.
Seconded by member Miranda Johnson. Thank you. Members, is there any further discussion on the motion moved by member Strites and seconded by member Miranda Johnson? Okay, if not, I will ask Craig to take the roll call vote on the motion moved by member Strites and seconded by member Miranda Johnson.
Thank you, Chair. On the motion made by member Strites and seconded by member Miranda Johnson. Member Strites.
Yes.
Member Miranda Johnson.
Yes.
Member Anderson.
Yes.
Sorry, yeah.
Yep,
Member Mary Alice Evans.
Parker is excused.
Member Duvashel.
Yes.
Member Gordner.
Yes.
Member Chair Egon.
Yes.
Thank you, Chair. The motion passes with Vice Chair excused, with Secretary Lidstone excused, and Member Evans excused.
Great.
Thank
6 yes, 3 excused. Motion passes. Thank you to everyone who joined us today. That concludes our business. Thank you to the members of the public, to the staff, and to the members of the board. This concludes our business. The meeting is adjourned. The time is now 11:44 a.m. Thank you.
Thank you.